Hello everyone, welcome back to the channel. My name is Shikha and I'm a legal intern at Lexis & Company. I'm a law student from UPES Dehradun. In today's video, we will talk about the doctrine of indoor management. But before starting the video, there's a small disclaimer that this video does not solicit any kind of promotion or advertisement as per the guidelines of Bar Council of India. And the only purpose for which the video is made is educational purpose. So let's begin with the video now. A person who is entering into any contract or business with the corporation or the company must have knowledge regarding its article and memorandum and other legal documents which are open for public inspection under Section 399 of the Companies Act. This is also known as the rule of constructive notice, which implies that whenever a person is entering into any contract with the corporation, it is presumed that he have the knowledge regarding the memorandum, the article of the company. So in future, if there is any inconsistency between the contract and the company, then the company shall not be held liable in this case. This rule have an exception known as the indoor management doctrine, which protects the outsider or the person who is entering into any contract with the business from any internal irregularity relating any internal procedures or activities of the corporation. It is presupposed that there must be knowledge regarding the memorandum and article of the company, but it is not required by the person who is entering into a contract with the company, and he shall also investigate regarding the internal procedure and processes of the company. So in case there is any inconsistency between the contract and the memorandum or articles due to the fact that there is irregularity regarding the internal procedure or the process of the company, then the company shall have a remedy against the corporation, and the corporation or the company may be held responsible by the court. This rule was firstly, or the first time, evolved in the case of the Royal British Bank versus Top Bond. So this is also known as a Top Bond rule. In this case, there was a corporation which can raise borrowing through bonds, but for this there must be a resolution passed in the general meeting. The company then raised a bond, but without any kind of general meeting held in the corporation. So the company was then failed to pay the bond money. So the company was here held responsible by the court because it was due to the fact that the internal procedure were not met by the company, and the outsider, that is the bond holder, do not had any knowledge regarding the internal procedure or the process which were not met by the company. So on his part, his activity were done in the good faith, but the company failed to raise the resolution in the general meeting. So here the company was held responsible. This rule of indoor management have certain exceptional circumstances where a person cannot hold the company is responsible when there is any irregularity in the internal matters of the company. The first one is when there is knowledge of irregularity. When the person or the outsider have any knowledge of irregularity, whether directly or indirectly, then he cannot take the advantage of the indoor management doctrine. The next one is when there is a suspicion of irregularity. When a person is entering into any contract with the corporation, then if there is any kind of suspicion regarding the contract, surrounding the conditions surrounding the contract, then he must inquire into it, because later on he cannot take the advantage of indoor management doctrine. The next exception is related to forgery. The transaction related to forgery here is null and void from the beginning itself. In the case of the Rubin versus Great Fingal Consolidated Fund, for a valid share certificate to be issued, it required the signature of the two directors and a secretary. But in this case, the certificate was issued, but the secretary forged the signature of the two directors. The holder of the certificate claimed that he had no knowledge about the fabricated certificate, and he was also not required to investigate into it because it was related to the internal procedure. The court here stated that the company will not be held responsible for the act of its officer. So he cannot, the holder of the certificate cannot take the indoor management exception. The next the next exception is related to any act which is outside the apparent authority of an officer. When an officer conducts such an act which is outside its authority, then the company shall not be held responsible for the such act of the officer. Also, if the officer is doing acts which are outside the apparent authority of his, so the next person is here required to investigate into it. But if he fails, or if due to his negligence any kind of damages or inconsistency occurs, then the corporation shall not be held responsible for the same. So the doctrine of indoor management is in helpful for the outsider, or the person who is contracting with the corporation from any kind of irregularity which is related to his internal affairs or the internal procedure, because normally such persons are not aware of the those irregularities, and also it is not possible for them to have knowledge regarding the same. So the company shall be held responsible in such cases, in such irregularities related to the internal procedures or the processes. So that's it for today's video. If you have any doubt or if you have any feedback, please write it down in the comment section below. Also, I have made videos regarding the doctrine of corporate veil, so please check it out on our channel NextClick. For more such videos, please subscribe and visit our channel NextClick. Thank you so much.